We should, and how that.
It says, we hold petitioners may invoke the fundamental procedural protections of habeas corpus. The laws and Constitution are designed to survive and remain in force in extraordinary times. Liberty and security can be reconciled. In our system, they are reconciled within the framework of the law. The framework has decided that habeas corpus, a right of first importance, must be part of that framework, a part of that law. For four justices in dissent, Chief Justice Roberts concluded, so who's won, not the detainees. The court's analysis leaves them only with the prospect of further litigation, not Congress, whose attempt to determine through best democratic means how to balance security and liberty has been unceremoniously brushed aside, not the great writ, whose majesty is hardly enhanced by its extension to a jurisdictionally quirky outpost, not the rule of law, unless by that is meant the rule of lawyers, who will now have a greater role than the military and intelligence officials in shaping policy for enemy combatants. Certainly not the American people, who today lose a bit more control over the conduct of this nation's foreign policy to unelected, politically unaccountable judges. And Justice Scalia, in his dissent, wrote, today, for the first time in our nation's history, the court confers a constitutional right to habeas corpus on enemy aliens detained abroad by our military forces in the course of an ongoing war. The game of bait and switch that today's opinion plays upon the commander-in-chief will make the war harder on us. It will almost certainly cause more Americans to be killed.
First, I went across the street to the other Yale Art Gallery, where they were having a panel on British watercolors, and I don't have much to say about British watercolors. I'm also glad to be here because I think that I probably first learned about habeas corpus at the Yale Law School, although it's hard to remember. Habeas is, as Justice Kennedy pointed out in his opinion, it is so fundamental a right that the framers of the Constitution put it in the Constitution at a time when they didn't believe a Bill of Rights was necessary. That is, the Constitution was initially drafted without a Bill of Rights. And yet they insisted that within the Constitution itself, one right be protected, and that was the right of habeas corpus. I think it's partly poorly understood because it's in Latin, and everything that's in Latin is difficult to understand. But I think the basic concept is very easy to understand, and I think back to a time when I was representing a man in New York who was being detained, a Muslim man before 9/11, who was being detained on secret evidence of charges of affiliation with a terrorist organization. And my son at the time was 3 years old, and he didn't really understand a lot about what I did as a lawyer. But one of his favorite books was Curious George, and the first Curious George book, and you know, the notion of this person, this monkey being locked up, this sense of injustice was, you know, he understood as a 3-year-old. I remember I went up to New York to argue this guy's case, and I called home to say hello to my son. My son said, so Daddy, have you got him out of jail yet? So that's what habeas corpus is about. It's as basic as that. Daniel Patrick Moynihan once said that if he had a choice between living in a society that granted him the right of habeas corpus and denied him the right to vote, or a society in which he had the right to vote, but not the right of habeas corpus, he would rather live in a society where he had the right of habeas corpus and the right to vote. In other words, it's more important than democracy itself. Nonetheless, it's been under major attack for several decades now, largely through the actions of the Rehnquist Court, which radically restricted the circumstances, as Judge Sarakin indicated, under which habeas corpus can be granted in review of convictions obtained in state court, as was the case in Reuben Carter's case. And so it is much more difficult to get habeas corpus, although it is still the case that in 40% of death penalty cases that are affirmed all the way through the state court system as having no errors whatsoever, in 40% of those cases, nearly half of those cases, federal courts exercising habeas corpus review have found constitutional error. So that underscores, I think, how important a only real opportunity for a defendant to get a federal court of unelected, politically unaccountable judges, and I think that's an important point, I'll come back to that, to hear their claim that they have been locked up unconstitutionally. Since 9/11, a major focus of habeas corpus has been a different focus, and that is habeas corpus to challenge executive detention. Very different, because in the context that Judge Sirican and Reuben Carter were involved, you had a trial, but it was in state court where you have elected judges who are often very, very affected by political wins and don't like to reach an unpopular decision. But in the context of executive detention, as is the case with the Guantanamo detainees, you're talking about people who've never had a trial whatsoever. And the Supreme Court has said that that is the core of habeas corpus. And so Thursday's decision from the Supreme Court essentially reaffirmed, in a sense, that core. Now, in one sense, I think that it's a relatively limited decision. It's just about the right to get in the courthouse door. It's not the right to actually be released. It's also just about the Guantanamo detainees. There are about 260 of them now, but there are something like 10 to 20,000 detainees around the world in Iraq, at Bagram Air Force Base in Afghanistan, and in secret CIA prisons around the world. And there's no certainty, indeed I think the odds are against it, that the right will extend to them. And in some sense, people might think, what's the big deal? Didn't the court already decide this 4 years ago in a case called Rasool versus Bush, the first time that the Guantanamo detainees went to the Supreme Court, and the issue was, do they have a right to get in the door? And the Supreme Court said yes. So why is it that 4 years later, they're essentially still at the threshold, just answering that initial question, do they get in the door? Well, the reason that the court is asking the question again is that in the interim, Congress responded to that first Supreme Court decision, which was based on a statute. The first time around, what the court said is, we interpret a statute that Congress has enacted that creates habeas corpus. We interpret it to apply to Guantanamo. And they said, if Congress disagrees with us, it's up to them. They can change the law. Well, Congress did disagree with them, and at President Bush's bidding, one of the last acts of the Republican majority Congress was to suspend, if not suspend, but to revoke habeas corpus as a statutory matter from the detainees at Guantanamo. So this case asked whether there is a constitutional right to habeas corpus that Congress cannot take away unless it engages in the extraordinary act of suspending the writ, which it's only allowed to do under the Constitution in times of rebellion or invasion. So even though it's sort of a redo, a do-over, and even though it's only about whether you get in a courthouse door, it's actually, I think, a revolutionary case in a number of respects. First, it's the first time that the Supreme Court has ruled against the President and the Congress acting together on a matter of national security in the history of this country. The courts have traditionally deferred to the executive, and especially deferred to the executive when he's acting in conjunction with a congressional statute, as he was doing here. So, the courts upheld the convictions of people for objecting to the war, criticizing the war during World War I. They upheld the Japanese internment in World War II. They upheld the anti-communist measures until the Senate censored Senator McCarthy, and McCarthyism was on the wane. The courts have been very deferential, and yet here you have a court not only standing up to the President, but standing up to the President and Congress acting together, never before. It's also the first decision to extend constitutional rights to foreigners outside of any U.S. territory. First time. Just 7 years ago, the Supreme Court said, the Constitution is of no solace to a foreigner outside of our borders. And yet here, they're extending it, not just to foreigners, but to people who've been described, as Jack says, the worst of the worst. And it's only the third time in the history of the court that it has struck down a congressional statute limiting its own jurisdiction. Something it very rarely does because, in some sense, the very fact that the court is unelected is seen as an important sort of legitimating factor that Congress can and has the power to limit the court's jurisdiction. That, in some sense, gives the courts buy-in from the democratic process. And so the court has been very reluctant to declare a jurisdictional statute unconstitutional, did so here. So revolutionary in three respects, very important respects. So the question, I guess, that I want to close with is why? Why was the court willing to do this? After all, this is the court, the same court largely, that has been radically restricting habeas corpus over the last 2 decades. Fundamental nature of habeas corpus, because it's only now in this decision that they say it's fundamental, and many, many others they have sort of given it the back of their hand. I think in part it's because it's a reaction to the extreme nature of the assertion of executive power that President Bush and really Dick Cheney have put forward in a luncheon the other day where John Conyers was speaking, and he was defending why he hadn't pushed for impeachment. He said, well, if we impeached President Bush, we'd get Dick Cheney. And he said, and if we impeach Dick Cheney, then President Bush would become president. So, and there is this, to which somebody else got up and said, yeah, but if we impeached both of them, Nancy Pelosi would be president. But the president really has asserted this notion that when he is acting as commander-in-chief, none of the other branches have any role to play in checking his actions. He's asserted it with respect to torture, said he could order torture even where Congress has made it a crime under all circumstances to torture. Asserted it with respect to wiretapping of Americans, where Congress has made it a crime to do it without court order. He said he could do it as commander-in-chief. And asserted it in the first Guantanamo case, where he said that it would be unconstitutional for the courts to review the president's decisions about who he detains at Guantanamo. So I think in some sense the kind of extreme nature of that assertion of literally unchecked executive power exercised by Dick Cheney from a secret location caused the court to step back. And in part because that assertion is a threat not only to democracy, but a threat to the court's very role as the body that says what the law is. I think the case is also attributable to the fact that Guantanamo has really become the symbol around the world of this position of the president that he is essentially not constrained by law. There's the Center for Constitutional Rights, which brought the first Guantanamo cases, and was the litigator in this case that was decided on Thursday, issued a report in which they quote an interrogator who says to an interrogator, you have no rights here, the law doesn't extend here. Guantanamo was famously claimed to be a law-free zone, and the court on Thursday was unwilling to go along with that. Guantanamo, after Thursday's decision, is no longer a law-free zone. But I think it's also consistent with an international trend that we're beginning to see in which courts of last resort in liberal democracies and not so liberal democracies are taking aggressive actions in reviewing assertions of executive power on matters of national security in the context of terrorism, something that would be unheard of 25, 50 years ago. Courts, the law lords, the highest court in the UK has declared the use of secret evidence against people subject to curfews for their terrorist ties illegal. The Israeli Supreme Court has declared the use of torture tactics against Palestinian suspects illegal, has limited the military's ability to shoot suspected terrorist leaders. The German Constitutional Court in the last 2 years has struck down 2 anti-terrorism data mining provisions as violating the rights of privacy of the German citizenry. And the Canadian Supreme Court has declared unconstitutional the use of of secret evidence. And I think what that reflects is that habeas is an example, maybe the most important example, of a broader lesson. And that is that there are limits to democracy. That democracy does some things really well, but it does other things very poorly. And one of the things it does very, very poorly is respond to the claims of people like Reuben Carter, respond to the claims of people like the enemy aliens held at Guantanamo. And so what I think all of these courts of last resort around the world, including the United States Supreme Court, are recognizing in their newly aggressive stance is that, in contrast to Chief Justice Roberts, it is precisely because they are unelected and politically unaccountable that we want judges to decide these cases of constitutional rights. And I'll close with one thought, and Harold's already alluded to it. But this case was decided by a single vote, and that only underscores how critically important the next election is.
We can't start from scratch. His case had a 10,000-page record. So good lawyering is what it takes.
But it takes more than that, Judge. It really takes more than that. I had more people in my batting for me, pulling for me. I mean, I had some of the most famous people in the whole world. The Muhammad Ali's, the Joe Frazier's, the Ellis Burstons, the Diane Cannons, the Coretta Scott King. I had all those people singing songs, writing movies, doing all of that. And I just narrowly slipped through the eye of the needle. And the only reason why I slipped through the eye of the needle was Judge H. Lee Harris. The only reason why. We need more judges like H. Lee Harris. We need more people like this.
And Congress, under a Democratic administration, President Clinton pushed the Anti-Terrorism and Effective Death Penalty Act, one of the oddest titles for a law until before the Patriot Act, which essentially sort of put into legislative form many of these restrictions that the Supreme Court had essentially made up as a matter of common law. And so those can be changed by Congress, and they could be changed in theory by the court, although I think it's much more likely from Congress, but only if we change the culture. And so I think the first thing we need to do is send Judge Sarakin and Reuben Carter on a national tour to help restore the existence.
When we do, fortunately.
Judges and public.
Necessary force, isn't that runs right in the face of the checks and balances systems that we have? In terms of the fact that that law was pretty much what was ruled unconstitutional against it?
Well, the question is, what is the appropriate scope of those powers? And that's what this case, the Guantanamo detainees have been litigating for 6 years. So it doesn't mean that that the president thinks it means that when it comes to anything that has to do with engaging the enemy, the authorization to use military force makes him commander-in-chief who can't be checked. But nobody has bought that argument other than Dick Cheney and David Addington, his chief counsel. So I don't think that. I mean, we're continuing to fight that battle, but I think we're winning.
Detainees and not being citizens. You have to remember that Jose Padilla was a U.S. citizen, although he's since been convicted of something. But he was kept for years in prison, a U.S. citizen, no hearing, no right to a lawyer, I think for 4, maybe 5 years.
This is a new world we live in, and terrorism is so terrifying that we have to suspend habeas or adjust it. And one of the things I discovered in my own work on this piece was that you may remember in the mid-1700s, King Charles I was executed, an act of terrorism by these Puritans. We call them pilgrims, and we love them, but in England, they weren't well loved. And after the Restoration, the Lord Proprietor he was terrified of these people, right? He killed the first king, so Charles II was in danger. So they just started locking up all sorts of terrorists on an island off of England. They think it was either Guernsey or Jersey, we don't know anymore. But he locked them up over there because that was outside the jurisdiction of the English common law and the Great Writ. And then after a while, that grew into a kind of abuse where he, instead of locking up just the Puritans, he was locking up his political enemies as well. And a man named Lord Shaftesbury sort of took him on, and the Parliament won, and in 1679 they passed the Habeas Corpus Act. And one of the things it forbids is moving a prisoner into, quote, Scotland, Ireland, Jersey, Guernsey, Tangier, or into parts, garrisons, islands, or places beyond the seas which are of, at any time hereafter, shall be within or without the dominions of His Majesty. So, and that Habeas Corpus Act we sort of lived under. It applied to everybody after 1679, except for 59 people, by the way. The high commissioners who executed Charles I were, by name, exempted from this act. And every one of them was hunted down without benefit of habeas and drawn and quartered. Some of them were dug up, had died in the meantime. They were dug up and drawn and quartered, then reburied. But fortunately, 3 managed to escape and cross the seas and found a town full of such anti-royalist, puritanical maniacs that they hid in this town and lived here for the rest of their lives and were never caught. And their names are Dixwell, Whaley, and Goff.
And so we live here in a town that's founded by the writ of habeas corpus. Let me arts fundamentally are about ideas. You're seeing the writ of habeas corpus represented in song, Bob Dylan's The Hurricane, in visual movies, the movie The Hurricane. You will see it in dance, Liz Lerman's small dances about big ideas, and in an idea expressed in law and legal opinion and contemporary debate, the discussions you've heard today. And I think it proves again why arts and ideas, as well as law, are so critical a piece of a democratic society. Thank you all very much.